The Palisades, a community devastated by wildfires, homes lost, lives destroyed, thousands of people were left to rebuild from scratch. To ensure that regulations wouldn't slow down construction efforts, Governor Gavin Newsom issued not one, but two executive orders, temporarily suspending certain provisions in California's signature environmental laws, the California Environmental Quality Act and the California Coastal Act. But why would a governor, who is known for his big government approach, try to curb government power? Why would such an action even be necessary? In 1982, Marilyn and Patrick Nolan wanted to convert their beach bungalow on the California coast into a two-story home. They applied for all the required permits, but a little-known government agency called the California Coastal Commission responded by demanding that the Nolans give up 1/3 of their property to the state. The reason? The commission claimed the second story would create a psychological barrier for passing drivers because it would partially block their view of the ocean. To compensate, the Nolans were told to allow public access through their private property. But what is the California Coastal Commission? And what right do they have to demand a quid pro quo, forcing residents to surrender part of their land in exchange for permission to expand their home? To understand that, we have to go back a few decades. Throughout the 60s, California's population grew by 25%, leading to rampant development along the once pristine coastline. Many residents grew disillusioned and worried that the natural beauty they loved was being paved over. So, in 1972, a ballot measure was passed to establish the California Coastal Commission, a state agency meant to protect, conserve, restore, and enhance the environment of the California coastline. By the time the Nolans submitted their permit application, the commission had amassed sweeping power. As you might have guessed, the CCC was given the authority to issue development permits on California's coast. But what you might not have guessed is what exactly counts as the coast. California has over 3,400 miles of coastline, but their jurisdiction doesn't just encompass the beaches themselves. In some areas, the Commission controls development for up to 5 miles inland, with small towns, rural communities, and prominent cities located within the sector. The California Coastal Commission's influence has been a big part of the decades-long housing crisis throughout the state, as they've prevented lawful development efforts. And even when not outright preventing development, the time and expense required to jump through the Commission's endless hoops creates a massive disincentive for developers. And as for what counts as development, we'll let you be the judge. Strike that, the California Coastal Commission is the judge. While it generally encompasses private building of new structures, solid materials, disposal of waste, grading, removing, dredging, or mining, things most reasonable people would agree on, development is also defined as change in the density or intensity of use of land. A fairly broad definition, as just about any new usage of land could qualify. For example, the Commission requires that cities obtain development permits before holding 4th of July fireworks displays. In the case of the Nolans, adding a second story qualified as development. The CCC demanded that the Nolans give up a portion of their private beachfront to the public in return. Figuring it was a losing battle, the Nolans conceded and signed the agreement. But soon after, Patrick discovered a case the CCC had recently lost, which gave him hope that he and his wife might be able to win against such a Goliath too. Patrick returned to the CCC's office, claimed he'd made an error on the forms, and asked for his application back. When the staff handed it to him, he tore it to pieces on the spot. It was the 1980s, so no paper, no agreement. From there, the Nolans partnered with Pacific Legal Foundation and filed a lawsuit, arguing that the CCC had committed an unlawful taking of property without just compensation. Their fight took years, but eventually it landed in the U.S. Supreme Court. The court ruled in favor of the Nolans, calling the CCC's actions an out-and-out plan of extortion. This case became one of the biggest property rights victories of the century, setting a precedent that now protects homeowners in all U.S. states and territories. But even this landmark win didn't stop the CCC. When Henny and Warren purchased their Malibu dream home in 2002, they had no idea that back in 1978, the original owners of the home agreed to an easement, granting public access to the beach on the south side of their property. There was just one problem. The home sat about 20 feet above the beach, with a steep drop-off over a large drainage pipe. So the previous owners installed a deck and stairway, providing private access to the beach, and a gate to protect the public from the drop-off. 24 years later, in 2007, the California Coastal Commission demanded that the Lents remove the structures to comply with the 1978 easement. The Lents objected for various reasons, including the fact that they were not responsible for building the structures in the first place, and even more importantly, because the gate was needed to protect the public until the commission was ready to build the accessway, something that had never been attempted at any point over the previous decades. The Lents even gave the state a key so they could unlock and use the gate whenever they wanted. But the CCC was immovable despite the dangerous situation that fulfilling their demand would create. So both sides went back and forth for several years until one day everything changed. In 2014, the California State Legislature handed the CCC an alarming new power to impose fines up to $11,250 per day to force compliance. 2 years later, the California Coastal Commission asserted its authority to issue the Lents a fine for denying access to the beach. Only they retroactively fine them for all 744 days that had elapsed since the Lents were informed their violation could expose them to financial penalties. The ultimate fine was a staggering and disproportionate $4.185 million. Warren Lent told the Wall Street Journal that such a fine would destroy a lifetime of work. On behalf of the Lents, Pacific Legal Foundation petitioned the U.S. Supreme Court to hear their case, arguing that the fine was a violation of the Eighth Amendment's protection against excessive fines, but the court denied the request. In the end, the Lents had to sell their home to help pay the nearly $4.2 million fine. As Warren Lent said, "When you sit down and the dust settles, you say, 'What did Warren and Henny Lent do? They bought a house on the beach to fulfill a lifelong dream.' That's all we did." And even after its battle with the Lents, the California Coastal Commission still has yet to develop an accessway to the beach. To add insult to injury, after the penalty hearing which required the Lents to remove the gate, the Lents offered to tear it down the very next day and were told to wait a few months to give the state time to prepare the replacement gate, which, in a profound act of redundancy, was then installed right after the original gate was removed. Years later, in a strange turn of events, the Lents' previous dream home burned down in the 2025 Palisades fire, and the only thing left standing was that damned gate. The CCC has a long track record of rejecting affordable housing too, which begs the question, what do they actually allow? CCC must respect a local government's local coastal program, or LCP, which is a land use plan and zoning ordinance that is supposed to control permitting decisions once the Commission certifies them as consistent with the Coastal Act. While far from perfect, LCPs were designed to provide developers with a roadmap for compliance, or so the theory goes. In 2003, Shear Development Company purchased 8 lots in a residential neighborhood, half a mile from Morro Bay in Los Osos, where they planned to build 8 homes in 2 stages. After they completed the first 4 homes, they sought permission from the county to finish building the rest.
I purchased the property originally with the intention of building 8 homes here, 1/2-acre lots. We were told that we were going to be able to build them. I wouldn't have put in all that infrastructure had I not been told that.
The county reviewed the plan and approved it, granting them a coastal development permit. But after the approval, the California Coastal Commission appealed the decision. The arbitrator of this appeal? The California Coastal Commission, meaning they were appealing the ruling to themselves. So naturally, they won, claiming enforcement power based on the project's location in an environmentally sensitive habitat area. However, the properties fell outside of that environmentally sensitive habitat area, according to the county's own maps.
What really irks me is that they didn't take the time to do their due diligence on this. Coastal Commission looked at it in about a minute. They made their decision and said no.
Now, if all of that sounds confusing, that's because it is. The short explanation is that the CCC isn't playing by its own rules, but is instead telling developers one thing and then swooping in after the project has begun and completely changing things on a whim. In the case of the Sheer Development Company, it's been a nearly 20-year nightmare.
It's definitely affected me, emotionally and mentally and all that stuff over time. Now it's just a complete loss of several $1 million for me.
So, Pacific Legal Foundation got involved once again, and the case has made its way to the California Supreme Court. For Tim, this is about more than just building houses.
We're just here to finish off what we were told we could do. It would help other people see that, hey, this guy got through it, maybe we can too.
A win will vindicate the company's right to build homes and force the agency to stick to LCPs as written, confine them to their proper role under the Coastal Act, and most importantly, it will build a firm legal foundation for all citizens to fight back whenever the CCC or any other government agency abuses their power. While preventing new construction along the coast has a big impact on the housing market, so does the CCC's control over the maintenance and preservation of current homes. In the original CCC mandate, they were required to issue permits for coastal armoring, designed to protect existing structures from being eroded by the ocean. In 2019, they issued permits to protect a 1974 apartment building, but denied them for a similar community built in 1984. The CCC reasoned that their mandate only applied to structures that existed at the time of the mandate, in the 70s. This case is still tied up in the courts as well, but it speaks to a larger pattern. Not only is the California Coastal Commission making it more complicated to get new structures built, they're also providing obstacles to protecting, preserving, and rebuilding already built ones. Because letting homes erode into the ocean or remain a plot of ash and debris will be good for the environment? This brings us back to the Palisades and the 2 executive orders Governor Newsom signed to keep the California Coastal Commission from interfering with the rebuilding efforts. The fact that he immediately took this action underscores how notorious the commission has become for its interference with much-needed development. The agency's power grab has gotten so egregious that both Democrats and Republicans agree something has to be done about the California Coastal Commission. While protecting our natural habitats and beauty is deeply important, we can't lose sight of the people living in those communities. If we are protecting so much land we can't build enough houses for people to live in, or we're preventing victims of natural disasters from rebuilding, what are we doing all this for? Building more houses on the California coast would be one piece in a large puzzle that would help alleviate the housing crisis, preserve the homes we've already built, and give people a chance to thrive. So let's build some houses